Okay, folks, again, this is Douglas Pinkham with Pinkham & Associates. We are a dedicated family law firm in Orange County, California. We do nothing but family law, divorce, and custody, visitation, child support, spousal support, domestic violence, those kinds of family law issues. All right, this video is a video on the FL 341, Child Custody and Visitation Parenting Time Order Attachment. This is a form you will fill out and attach to a judgment if you want to use this form to make orders for child custody and visitation schedule. All right, then let's move on. Let's start at the top. Again, just like every form, petitioner and respondent's names. Oh, by the way, if you don't have the form in front of you, there's a link below. Click that and have the form in front of you while we go through it. You can pause this, print it out, come back to it, because we're going to start going through it line by line right now. All right, folks. At the top, petitioner and respondent's names. They never change, again, like I say on every video. So put the right name in the right slot. Then the case number off to the right. All right. Now, up here on the top, it's asking you how are you using this form? Are you attaching it to an order? Are you attaching it to a judgment? What kind of judgment are you attaching it to? Are you attaching it to a findings and order after hearing? So you can attach this to a findings and order after hearing, which we don't have it yet, but I will be putting a video up with regard to putting together a findings and order after hearing. But you're likely attaching this to a judgment, either a paternity judgment, an FL 250, or a divorce or dissolution or legal separation judgment, FL 180. And it could also be part of a stipulation in order for custody and visitation. But mark the appropriate box up here that you are attaching it to. Let's just say it's part of a regular divorce judgment, and if so, you're going to mark that box that says Judgment Form FL 180. 180. Then we're going to go down, and you can read through these things. You should know this stuff, so I'll read through it real quick. Number 1 says jurisdiction. The court has jurisdiction to make child custody orders in this case under the Uniform Child Custody Jurisdiction Enforcement Act, which is Family Code Section 3400 et sec. That is just standard language that's already printed in here because the court needs that jurisdiction to be able to even make the orders. Number 2 says notice and opportunity to be heard. The responding party was given notice and an opportunity to be heard as provided by the laws of the state of California. 3, country of habitual residence. You're going to mark the United States, or you're going to have a problem filling out or filing this form. Okay? Then penalties for violating this order. If you violate this order, you may be subject to civil or criminal penalties, or both. That's a standard statement we put in all judgments that have custody visitation orders, because we need to give that notice. It simply says that if basically if you kidnap your kids or you withhold them from the other parent, controverse to any child custody order, you can get in trouble. You can get in trouble in family court, civil law, or if you kidnap a kid and bolt to Bolivia, you can actually get in trouble criminally. So that's why 4 is there. No big deal. All right, so we're going to make custody orders. That's why we're filling out this form. So mark 5, child custody. Then we're going to put the names of the children. If you have 6 children, there's plenty of room here to list 8 or 9 kids. If you have more children than that, then you're going to need to just do an attachment and entitle it Attachment 5, Child Custody, and then list the kids and all the information in the same order and in the same manner it's listed on this form. And then you would just attach that form to the back of this form when you submit it. Okay, so it's asking for the child's name, the child's birth date, then it's asking for who is going to have legal custody. Legal custody is, and there's a legal custody form to follow this. So, but generally speaking, legal custody is that right of a parent to make decisions for a child with regard to health, education, and welfare. Can a child change schools? That's education. That's a joint custody, joint decision that needs to be made if joint custody is the order. Can a child join the military before 18? That's a joint custody order. Can a child get a tattoo before they're 18, before they're able to make that decision as an adult on their own? That's a decision that needs to be made by both parents if you have joint legal custody. So, if you have, and by the way, generally speaking, there's always joint legal custody unless there is some serious reason why there should not be joint custody. Maybe one of the parents is in prison and doesn't have the ability to make contact and make decisions with regard to school or education or a doctor visit or something like that. That might be one reason why you would have sole legal custody. But if you need some advice on that, talk to an attorney. But generally speaking, that's going to be joint legal custody. Physical custody, if one party has the majority of the custody, you can put that party's name in here. Put their actual name, Jane Doe, John Doe. Let's say Jane Doe has primary custody and she's got 80% custody and John Doe's got 20% visitation. Then that's what you would put in there, and I forgot, I'll just put joint legal custody here. And you would do the same for as many kidders as you have. So go through this and fill that out correctly. All right, number 6. If you believe that there is a chance of child abduction and you want orders with regard to child abduction prevention, mark 6, and there's another form, and another one of my videos will tell you how to fill out the FL 341B. Go see that video. You don't really want to make this allegation unless it's a real problem. So don't mark 6 unless it's a real problem. So you think that the other parent is going to scoop the kid up and take the kid, say, out of the country or abduct the child in some other manner. All right, next box is visitation parenting time. All right, if you and your partner or the other parent of your child have agreed that you're going to just agree to what visitation schedule there will be as time goes by, and you'll just give each other a call and figure it out as you go, but without any specific set schedule, then you should mark A, reasonable right of visitation to the party without physical custody. And by the way, it says, and you need to know this, not appropriate in cases involving domestic violence. So if there's a domestic violence restraining order, there's probably either a custody visitation schedule attached to or made pursuant to that restraining order, or there may very well be no visitation. So, and for some reason, if there is no visitation, you'll mark no visitation or parenting plan. But more likely, you're going to have one of these other boxes marked. B says, see the attached 2, 3, 5, 8-page document. You might very well have a stipulated judgment that you have typed up and included. And if you have that judgment typed up and included, let's say it's 10 pages long, or 20 pages long, which would be more likely, you could put see attached 20-page document, and that'll be the stipulated judgment. You should write off to the right here what that document is or what it's titled. So I'm going to put stipulated judgment here. Let's say, for example, though, that you don't have anything else written. You don't have an attached document. You could mark E and then actually put the schedule into this form. So you're going to fill out this form on your own. You're going to have to figure out what it is for your child's schedule. But I'll walk through it a little bit. So E, visitation. If you know the visitation schedule, you're going to mark E, and you're going to say visitation for the, and let's say for the other party, let's say it's the respondent, will be, and let's say it's every other weekend. Now you should see what's upcoming, so you know the difference. This one says weekends starting, and you can pick first, second, third, fourth, or fifth weekends of a month. If it's every other weekend, you can go right to E and mark alternating weekends. So that's what I'm going to do, because it's very standard to have alternating weekends. So let's go back to the front page so we understand. We're talking about weekends here. So we know it's alternating weekends, so I'm not going to mark 1. I'm going to go to page 2, and I'm going to mark alternating weekends. And I'm going to fill that out in a second. As a caveat, let's go back to page 1. Let's say, for example, instead of doing every other weekend, you want an order that says dad or respondent or petitioner, whoever it is going to have the first and third and fifth weekends of every month. And let's say, for example, you should know that there's 4 fifth weekends a year. Every third month there's a fifth weekend. And you should also be aware that if one party has the fifth weekend, they're also going to have the very next weekend in a row, because that's going to be the first weekend of the next month. So, but you can do that, or you can say that parent has the second and fourth, or whatever you want to mark here. And if that's what you guys agree to, then you can mark that here, and then you can put it in here and say from Friday at 6 p.m. Or you can say it starts after school and not mark anything here. It depends on what your agreement is. And then you can say to or until, you could say Monday at 8 a.m. when the other parent returns the child to school. Or it could be Sunday, very common, Sunday at 6 p.m. is when it ends. So on this order, we've got it set up to start Friday, Friday after school. Okay, start or start of school I've marked. That's okay. Let's say it's after school then. So let me correct that. Let's say it's Friday from after school until Sunday at 6 p.m. That's very, very common. Okay, so you can see how you can fill this out in different ways depending upon what's appropriate and what you guys have agreed on in your case. And here it's got special orders with regard to that fifth weekend. You can alternate that fifth weekend, and that's how you'd put that in here. And this next one is just going to confuse everybody. So, not you. I mean, let's say, for example, there's a problem with custody and visitation, and you call a police officer, and you show them this, and 1B down there is marked, and it says every fifth weekend in odd-numbered months or even-numbered months. Trust me, the wrong police officer shows up, and they're going to be looking at calendars, and they're not going to enforce it if they don't get it. So try to make this order as simple as possible. So I'm going to get rid of this and try plan B. Let's say we're not going to do it on an alternating schedule, we're not going to do the first, third, and fifth, or second and fourth, or any of that. We're going to go to this next page, and we're going to call it alternating weekends. Commencing, and you must have a commencement date, or it would be impossible to figure out which weekend is yours. So let's say you're going to commence it on May, let's pick a Friday. I don't know what date this is going to be. Let's say we mark it, but you want to pick it on a Friday. If your week starts on a Friday, and let's say the 14th of 2018. So I don't know if May 24th was a Friday, but we're just picking a date here. Oh wait, let me ask this. Here's it. All right, well, let's call it May 15th, because that is a Friday. So let's say this schedule is going to commence on Friday, June 15th, 2018, and we're going to make the visitations from Friday at And let's say the same thing. Let's say from after school, or you could do from 6 p.m. You can see right there. But let's make this from after school because it's really common. And let's make this until Sunday evening at 6 p.m. Again, if you want to make it until start of school Monday morning, you could do this. Monday, no time, just to the start of school Monday morning. Okay? If you are also going to have a midweek visit, that's where this goes. Number 3, weekday visits starting. Let's have it start on the same day because that's when our judgment's going to take effect. And let's say it's, well, better. Let's say, for example, it's going to be a Wednesday visit, and you're going to get Wednesday the 20th, and that's when it's going to commence. So let's say Wednesday from after school, and then returning whenever you want. Let's say it's the same night. It's a dinner visit, let's say. And let's say it's Wednesday after school until 8 p.m. Could be 6 p.m., could be 7 p.m., or it could be overnight. And it could be until every Wednesday until Thursday morning, start of school, off to the right. So you get the child from after school, or the other parent gets the child from after school on Wednesday until Thursday morning return to school. It could be Thursday night overnight, could be Friday night, or it could be Tuesday, could be whatever. If there's a midweek visit, and if there's multiple nights, sometimes a parent will have a Tuesday overnight and a Thursday overnight. And if that's the case, you're going to want to write that out. You could do the Wednesday here, but then if there's another night, you can put it down here in other. Excuse me. Got myself a cold. All right, folks. If there is a visitation order in place, you're not going to mark that stuff above, obviously, and you would mark supervised visitation until further order of the court. Or if you're not agreeing to something and you want supervised visits until further order of the court, you'd mark that. And you're going to, let's say the respondent, the other party, or maybe you're the respondent and it's the petitioner, whoever, you got to mark the right party here and give their name here. Let's say it's Jane Doe. And she needs monitored visits because she's not so good to be alone with the kids. We'll have supervised visitation, parenting time, with the minor children according to the schedule set forth on page 1. And remember, we go back to page 1, and that schedule might be no visitation or reasonable visitation, but monitored. So you need to fill this out as it applies in your case. All right, folks, if there's no monitored visits, which, monitored visits are relatively common. Yeah, they're common, but more cases do not have monitors, obviously. All right, so transportation for the visits. Standard order for transportation is the receiving parent transports. So if you are getting the children, you go get the children at mom's house or school or whatever. Then if you, at the end of a visit, if the children, let's say, are going back to mom, then mom would have the duty of collecting the children. So going to dad's and collecting them or whatever. That's standard. You'll notice here that it says children must be driven only by a licensed and insured driver, and the car or truck must have legal child restraint devices. So if there's a little kidder, you're going to need child seats, and they need to be proper and legal and installed correctly. That's a problem if they're not even installed correctly. If they're not children, then you use regular seat, not little kids, then you use your regular seatbelts. Okay. Transportation at the beginning of a visit is going to be by whoever you agree to or whatever the order is. Transportation from the visits are going to be up to whoever. There's a handy little one here that says, let's see. Okay, then the next one, let me just keep going. D says the exchange point at the beginning of the visit will be at an address or some like Target in, Brea. Or it'll be, or you can put whatever there. Police department in Chino Hills. E says the exchange point at the end of a visit will be, and it might be the same place. Or if you're just picking up at the other person's residence, you don't have to put anything in there. F says during the exchanges, the party driving the children will wait in the car, and the other party will wait in his or her home or exchange location while the children go between the car and the home. So if your children are old enough to walk from the house to the curb or from the curb to the house, then you guys should stay apart if you need that. I mean, obviously, if there's a restraining order, but there's still custody and visitation orders in place, you want to mark this box. If there's no concern and there's no big deal about communications, then you don't have to mark that box. Other. So if you want the receiving parent to be the transporter of the children in all visits, that's standard law. You could just put receiving. Receiving parent transports. Okay? Then, travel with the children. This is talking about out of the state of California or to or from other countries. And if you want restrictions with regard to that, if you have a parent that's from Mexico but you're afraid to have the kids go to Mexico, you might want to have restrictions in here. If you want, if the other parent is not trustworthy and you want them to be restricted on where they can go, and let's say, for example, you want to restrict them to just your county and maybe a couple of surrounding counties that they can travel in for fun or whatever they want to do with the kids, then you can list those counties. Down here in Southern California, it's not uncommon for these kind of situations where we need to make restrictions where we'll say that you can travel within or about Los Angeles County, Orange County, Riverside County, San Bernardino, and sometimes San Diego County. We sometimes add Ventura County to that list too to make sixth, depending upon what the restrictions are. I mean, you want the other parent to be able to, go freely and have fun with the kids. You might want them to be able to go to Legoland, but you live in Los Angeles County, but they've got to go down to San Diego County to get to Legoland. You don't want to have new orders every time they want to do something like that. So you could list in here that they will do that. Okay. And so that's that section. Going on to page 3. All right. So the next section, 11, is about holiday schedule. If you have a specific holiday schedule that you want to list, I would suggest that you leave this blank or you say holiday schedule in the attached schedule. And there's another form that spells out holidays very, very clearly, and it's the FL 341C. And I have another video on that. So go see the FL 341C video to set up a holiday schedule. If what you're planning for your holiday schedule is just for Thanksgiving and Christmas and it's pretty simple and straightforward, you can type it into this section. All right, additional custody provisions. There is a form, an FL 341D. You can go look at that form. It's very, very seldom used, but go look at it, and if you want to use it, it's very self-explanatory. Fill that out, and you can include that with your judgment if you want to. Joint legal custody. I have a video on this form. It's an FL 341E. That's a very important form if you have joint legal custody. And almost invariably, you're going to have joint legal custody. So mark that and mark in the attached schedule joint legal custody form. Okay, folks. Access to children's records. You can mark this box, but I think it's Family Code Section 3025. I could be wrong, but it's just off my head. Says that both parents automatically have an equal right to access to children's records, school records, and those kinds of things. That's what this is talking about. You can mark the box just so that a parent that does not have primary custody would be protected, and this would say, yeah, they can go get records for them, even though it's standard. Okay, then 15 is other. If there's something else that you want to put in here with regard to custody and visitation, this is where this goes. Now, there's no signature or date on this form. This is a form that gets attached to other forms. For example, a judgment packet or a child custody order. So no need to sign this form. That's it. That's the rest of this form. So again, this was the FL 341. I hope this video has been helpful. Thank you very much for watching my video.